Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? Welcome back. We're here for a semi-last minute live after about a week off with no lives because I was in trial, jury trial, Pasco County, full week, really tough case, really interesting trial, really stressful. We did get it done, and it was a pretty good sized verdict we were excited about. And we'll talk more about that, I'm sure, in other videos. But today you are here to talk about Lori Vallow and what's going on. A lot of you sent me the hearing. She was smiling and laughing and very awkward and uncomfortable when talking about a case where she's indicted for the murder of her children. I see Emily asking, anybody know the backstory for this one? So check out our page because we've gone in depth in the backstory and the complaints and what these cases are about. But generally speaking, it is about a couple that people say are part of a doomsday cult that got together and then people in their lives started dying. Exes, siblings, children. And they have been indicted for some of those murders, some conspiracy to commit those murders, and some conspiracies to steal the Social Security money from the children that died. They disappeared. They left to Hawaii. They were all over the place. Missing children reports were filed. They didn't look for these kids. They didn't help find these kids. And they were found on the property of the new husband. So Chad Daybell and Lori Vallow Daybell are the two that were indicted in all of these crimes. And there will be a lot of discussion as these trials come up. But I do want to focus today because I've done some more general videos on this case and on this trial. Thank you, Corin. So I do want to focus specifically on this hearing filed by Lori Vallow's lawyers because there are some interesting arguments made. They first make the argument that the aggravating factors that get us up to a death penalty type case should have to be proven to have probable cause in front of a grand jury. And the second major argument was counts 1 and 3 that talk about conspiracies are too confusing, don't make sense, shouldn't be put in front of a jury. They should have to go back to the grand jury and discuss whether or not these charges even make sense, what they're proving, what elements they're going to have to put in there. And that was a very interesting argument. Yes, this happened in Idaho, Samantha. So we're going to take the easier argument, the aggravating factors one first. It was much quicker, and I think it's going to be much easier to call what happens. But first, let's get to Bev's comment. I've pored over this case since Tylee and JJ vanished in 2019, to say nothing of the deaths of Joe, Charles, Tammy, and Alex, an attempt on Brandon B's life. Thank you for diving into this, Peter. It's chilling and so complex. Yes, it is. And anybody who's not familiar with this case, just based on Bev's comment, you can see how complicated and how many different people are involved. And I have done videos diving into these facts specifically, so you should check that out if you haven't already. I know a lot of you that are here from other cases, enjoying a good time. Yes, Nicole, this shirt is from you. And it's awesome. Like I said, it's one of my favorite I've gotten. And Azam, I am back with a new haircut. And this week, this is going to be a really fun and content-packed week for all of you. Thanks for sticking through here and for coming back after the week off. I know you got plenty of people you can listen to, so I'm happy and appreciative that you're here. But this week, we're not only going to be talking about Lori Vallow, we are also going to be talking about the Vanessa Bryant case, which is directly following this video, a trial update, 4 o'clock today. That video is going to drop. Tomorrow, we're dropping part 5, reacting to Amber Heard's depo, the 2016 depo. We've got a Deshaun Watson case update with the civil lawsuits and the settlement with the NFL. We've got more live golfers filing lawsuits. We've got live golfers dropping out of the big antitrust lawsuit we're going to discuss. And then one day this week during lunch, I am going to have lunch with you, and we are going to listen to Camille Vasquez's podcast that I think is about an hour long that she did. That there's a YouTube, it's a video, but it's just audio. We can watch that together, analyze it, react to it together while we all eat lunch. Most of you are not in the same time zone. So if you're not in the same time zone, maybe you'll be doing something else, like Azam, who will be staying up late at night if we're talking about noon my time. So thank you, everybody that has joined us. Let's jump in to this case. Rich Cat, why would something that seems so obvious take so long to process? We want this to be right. And in our country, death is different is the saying they have. And because it's a death penalty case and people's lives are on the line, we want to make sure we get it right. We want to make sure there's no appellate issues. We want to make sure we don't have to do it twice. Try them, convict them, some appellate issue, they get off, then you have to convict them again. And if they're innocent, we want that innocence to be proven. If they're not guilty, we want them to know, or we want to have the criminal justice system be in the right place where they do not get convicted if they are not guilty. So we want to make sure we do it right. And yes, Catherine, because it's a death penalty case, it is more complicated. And last, this is the last question I'm going to get to because it's already been 6 minutes. People get annoyed when I'm not into the content. Very quickly. Kim, your care packages did get here, and you will see those shirts in videos this week. So here we go. Update on the travelers and insurance cases. I have not seen any updates on that yet, but if something comes through, send it to me on Instagram or Twitter. Handle right here at Dragos Law. Let's jump into this case, okay? So a very interesting argument was made on the aggravating factors. The defense lawyers for Lori Vallow say that there should be a probable cause hearing, even though they agree that the Supreme Court of Idaho has already decided this issue, that you do not need to send these aggravating factors down to the grand jury to find probable cause, and you can still charge them and go for the death penalty. And the defense lawyers make this very novel argument. They say, we realize the Supreme Court of Idaho is not on our side, but Judge, we want to make this argument on the record because, as we've seen in our country, longstanding law, even made by the Supreme Court, can get overturned, just like Roe v. Wade. They literally make that argument in the hearing, that because Roe v. Wade got overturned, now no law is safe, and the Supreme Court of Idaho's law may get overturned. Therefore, we need to put this on the record that these aggravating factors should have probable cause found by a grand jury. The judge took it under advisement. We'll decide later. The prosecutor basically just said, law is clear, Judge. I don't know what else to argue when all the law is on my side. No requirement that the state should show probable cause for aggravating factors. I am very confident the judge is going to deny the defense's motion, and they will not have to prove probable cause for the aggravating factors in these cases for Lori Vallow. I am pretty confident there. But the more interesting argument, John, welcome back to the lawyer. Not familiar with this case. Can you give a quick synopsis? So we are going to actually read, John, as part of our discussion. I figured some of you may be new to this case. And as part of our discussion, we are going to read the indictment for Lori Vallow, the charges that she is charged with. For a factual background, I really want you guys to go check out my other videos on this. I have a whole playlist, and I want you to go check those out so that you can really get the deep dive. I won't do it justice if I just go over it in 30 seconds here. So counts 1 and 3. There are conspiracy counts. And before we read them, this is very important. This was so awesome about having all of you in this community here with me. And again, when we talk about that trial I had last week, a lot of credit goes to you all because I've never felt better during jury selection. I've never felt better in talking to the jury. The very seasoned top dog at Wickersmith came up to me after the trial and said, you have a great presence with the jury you can't teach. And I told him I do a lot of YouTube videos where I talk with prospective jurors all around the world. And they really help me understand how when people say one thing, this is what they're thinking. And this is what people want to see out of a lawyer. And this is what they want to see out of a case. And they're a lot smarter than we give them credit for sometimes. And it helped me a ton. And again, we'll discuss that more later, but you guys are awesome. And yes, Coffee Buzz, but it's not homework. It's homework we're going to do right now in class. So the main argument for the defense attorneys in this case is that these conspiracy charges are confusing. The conspiracy ends when the murder happens or the crime that they're conspiring to commit happens. And in this case, they're saying conspiring for 2 different crimes, murder and grand theft. The murder of the children and the grand theft of their Social Security doesn't make sense. You can't tag one conspiracy onto another. This should have to be split into 2 separate conspiracy charges. And if so, it needs to go back down to the grand jury. It is fundamentally unfair. The state has not put all the elements they need to prove for each one. And this does not make sense. Now, before I tell you what anybody else said, I want to know from you all, when we read this indictment, does it make sense or does it not? Would you be able to answer this question or would you not? I almost always agree with defense attorneys in situations like this because I want it to be clear. I don't want to trick the jury. I don't want to mislead the jury. I don't want to give something the jury may not understand, not because they're stupid, but because it doesn't make any sense, right? I'm not calling the jury stupid. I'm saying, and you'll hear, because I'm going to read you what the judge says about it, that maybe these charges just don't make sense. The prosecutor objected and said these were untimely. There was some bickering going back and forth about, well, the prosecutor did some things that were untimely. The judge gave the prosecutor the chance to withdraw that objection. The prosecutor didn't. The judge said they're denying the untimely objection because the judge has discretion to do that. And he found good cause in this case because of the volume of discovery and the significance of this case. This is a very serious case. Okay, so conspiracy. The prosecutor argues it can be to commit multiple crimes. And they think there are 3 separate conspiracies. And there only has to be an agreement and an overt act. You don't have to actually prove the elements of the conspiracy, which is correct. And the judge asks again, there are 3 separate conspiracies. Prosecutor says yes. The jury instructions say crime or crimes with an S, the prosecutor says. Therefore, that's building in that there can be more than one crime that is conspired to be committed. But the judge says, don't they have to at least hear what the underlying elements are to see if there's an overt act, to see if they were conspiring to do this actually? And the prosecutor said, kind of. Then the judge says something very interesting. He hasn't seen charges like this with the unrelated crimes under a single count, and even he is a little confused when he reads them. Does the jury need to find murder and grand theft? Based on the language, it could be unclear. Prosecutor says there's no authority to do that. The jury will already see it. The grand jury has already determined this. The grand jury was able to figure it out. So why wouldn't the jury in this trial be able to figure it out? Very interesting. Then the judge asks, well, what about the sentences? There's a bigger sentence. There's a smaller sentence for the conspiracy to commit grand theft. I think it's 14 years. And then it can be life or death for murder. So which is it? Prosecutor said the smaller sentence is usually swallowed up in the bigger sentence, which is usually true on crimes, but not when you're saying to conspire to commit both, because which did they conspire to commit? Because if they find that they only conspired to commit grand theft and not murder, but they check yes on a conspiracy to grand theft and murder, I can understand how that would be confusing. And the defense attorney says, well, a person's life is on the line. We can't be too careful. The judge takes everything under advisement and will make the decision in the near future. So let's take a look here at this indictment together. And I want your expertise as potential jurors who are not lawyers, because if this is confusing to you, then the defense is correct. It's count 1 and count 3. Conspiracy to commit first-degree murder and grand theft by deception. Okay? And is a very important word, not or. It's not one or the other. It's did they commit both? The defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, deceased, that was Lori Vallow's brother, and other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the county of Madison, state of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. Count 3 is exactly the same, but just for JJ, so we don't need to read it again. But that is the basic count. And then it says overt acts. And here's a little synopsis for John and those of you that don't know a lot about this case. In furtherance of the conspiracy to commit murder in the first degree of Tylee Ryan and grand theft by deception, and, so those ands are really important, and to effect the objects thereof, one or more of the following overt acts were committed by one or more of the subjects of the conspiracy as part of the continuing criminal transaction and common scheme or plan within Madison and Fremont counties or elsewhere in the state of Idaho. Number 1, on or between October 26, 2018 to June 9th, 2020, Chad Daybell and Lori Vallow did endorse and espouse religious beliefs for the purpose of encouraging and or justifying the homicide of Tylee Ryan. On or about August 16th, 2019, Lori Vallow did change the deposit of Tylee Ryan's Social Security benefits from Tylee Ryan's JP Morgan Chase account to deposit money directly into Lori Vallow's personal BBVA bank account. On or about September 1st, 2019, Lori Vallow did move from Chandler, Arizona to Rexburg, Idaho with Alex Koch, Tylee Ryan, and Joshua Jackson Vallow, or JJ, or hereinafter known as JJ. On or about September 8th, 2019, Chad Guy Daybell Googled SSW wind and visited a website entitled, "What is the definition of SSW wind direction?" On or about September 9th, 2019, Alex Cox did go to 565 Pioneer Road, apartment 175, Rexburg, Idaho. On or between September 9th, 2019 and February 1st, 2020, Lori Vallow failed or refused to contact the Social Security Administration as required by law to inform the Social Security Administration of Tylee Ryan's death. On or between September 25th, 2019 and January 22nd, 2020, Lori Vallow did wrongfully continue to collect 5 months of Social Security survivor benefits on behalf of Tylee Ryan. So if I read you that, what would you think they are trying to charge Lori Vallow with? What are they trying to charge Lori Vallow with if I just read you that? Now, disregard the title, because obviously you can know by the title. But to me, as I read it, it sounds like they're trying to charge her with grand theft. Yeah, fraud. Tori, great point. Fraud. It sounds like fraud, right? She is trying to steal these Social Security benefits. Yes, everybody is saying, thank you, Angela. Everybody is saying fraud. Sounds like fraud. Sounds like fraud, not murder. Theft. Okay, so some people saying murder and theft, both. Theft. So regardless of the title, because I see a lot of you here, I agree with most of you, which I love when that happens. Fraud and theft really feels like the main point, especially of these overt acts. And so to add in the conspiracy to commit murder and grand theft there, I think is confusing, and I think you've proven that. And yeah, theft more so than murder. So here's the point, here's the fix, and why I would lean towards granting this motion by the defense is go back to the grand jury, put before them conspiracy to commit grand theft and conspiracy to commit murder as two separate conspiracy charges, and then everything's fine. In my opinion, that's what I think should happen, and I think they should do in an abundance of caution to make sure things are fair and they can know exactly what they're charged with. We want defendants, criminal defendants in our country, to know what they're charged with. So to me, I do think they have a point, Lori Vallow's defense attorneys. I do think they should win this argument, and I think that that's the way the judge is leaning based on his questions. Now, technically speaking, the state has just so much discretion to do whatever they want with charges that maybe they'll lose and they'll go forward and probably get convicted, and maybe we'll never hear about this again. But I think about every case and every part of a case very specifically. I try to think critically about it, and if this was going to apply to other cases where maybe there's less evidence, or maybe it's not such heinous facts, this seems objectively unfair to me and not how our laws are supposed to be written and not how our laws are supposed to be prosecuted. And if you're looking for justice as the prosecutor, to me, this isn't it. This isn't the cleanest way to do it, in my opinion. And if I was the prosecutor, I would want it to be cleaner. What sucks about this is probably going to take more time, probably going to start more clocks ticking, delay the cases, more continuances, which nobody wants, and I understand that. But it may be necessary, in my opinion. I see a lot of people saying common sense. Absolutely. That's another thing I used a ton in my trial this week. Use your common sense. I see people complimenting my haircut. Thank you very much. And if you saw the trial picture, I also had a much thicker beard after the trial. Clean it up a little bit, cut it up a little bit. But I will tell you, a lot of people always ask me, and actually my expert witness, the doctor in this case, was like, golly, you're really letting your hair go and stuff. You look like a wild man. And then after the trial, he said, all right, I guess your Jesus juice or something like that worked on the jury. And I do think the jury likes lawyers that look a little different than they used to, and we've talked about that a lot, but that's neither here nor there. Well, again, we'll dive into that and talk about it a lot later. Nicole, thank you so much for the big super chat here. Yay, Lawyer You Know returns. Going to be a part of the replay crew for this one. Must sleep. Big presentation tomorrow. Lunch and learn the extended version, but it is great to have you back. Nicole, awesome. Thank you so much again for this and for the Greek flag waving and part of the rewatch crew. So you will see this shout out. Thanks for the shirt. I saw some people saying this shirt is clean, and it is. Bev, Peter, I'm no attorney, but the prosecutor, Rob Wood, made a heck of an argument regarding the two different counts of conspiracy, Chad and Lori murder and fraud. I'm surprised there aren't more conspiracy charges. That's the point, Bev, in my opinion. I think these conspiracy charges should be separated out. I definitely think there's an argument for conspiracy, no doubt about it. And people ask me all the time, why even charge conspiracy? Well, if God forbid they think that only Chad is the one that committed the murders or only Lori, but they do think there was a conspiracy and they work together, well, you catch them with that. And then prosecutors love to tack on charges, tack on jail time, tack on conviction. So there's all sorts of reasons why you also do conspiracy. Alexandra, I'm not familiar with this case, but if it's crimes isn't supposed to be different trials for each crime, not different trials, Alexandra, but different counts, definitely. So they should definitely be separated into different counts, but they can try them all together in one trial with the same set of facts and circumstances. Patricia, can't they use the jury instruction to clarify the charge? So glad I asked you to check out this case. You make things so much easier to understand. Thank you, Patricia. I appreciate that. And they can to a certain extent, right? So it can't just make no sense. And the judge even said, if we were going to try to do this and put all the elements of every crime and all of these conspiracy things with the different potential punishments, that makes it a little more complicated. So I'm not sure we want to do that. Rich Cat, what if it was murder and writing hot checks? Would they have combined those and only focused on the hot checks too? So I would say no, you need to separate separate conspiracy charges and separate conspiracy counts where there are separate crimes being conspired about. Connie Lenicki, isn't the grand theft a result of the conspiracy and murders? So, or you could say they did the murders to get to steal the money. But I think the point is exactly what you're asking. It's confusing. And I don't think that this count is specific enough to tell Lori Vallow what she's charged with, how she can fight it, where she needs to specifically fight. Because to me, I would fight against the grand theft allegations in that conspiracy charge, not the murder allegation. So having it say murder and conspiracy, and then do I win? If they prove conspiracy but not murder and conspiracy, technically I think the state loses because you said and, so they have to prove murder and grand theft, the conspiracy for both. And if they only conspired for one, it's very technical in criminal law. Jeannie Burchetto. Hi, Peter. Since Chad and Lori will be tried together in 2023, could the jury find Chad for life in prison to give Lori the death penalty? Yes. It's going to be separate. They are two separate defendants. They can find whatever they want for both of them. And like I said, they can find only one of them actually committed the acts, but the other one, or both of them, I should say, conspired. So that's one of the other reasons why you add a conspiracy in here when you have multiple defendants you're charging with this stuff, is if they determine who actually was the one that committed the crime, they can get both of them for the conspiracy. Thank you, Virginia Tracy, for the super sticker. We can pull that down. I knew you guys were going to give me good info here and let me know if a jury actually would get confused. Although I do always say, I think this is a little easier for you guys than your average juror because you're into this stuff and you see cases like this and you've seen trials and you've seen depositions and you watch lawyers on YouTube and you watch or you look at documents like this get broken down. So I do think it is a little bit different than your average juror. Jeannie, oops, sorry, I got this one. Let's see what other one is here. Okay, so while we get some more questions in here, I wanted to say thank you for everybody that joined in on this live, that stuck with us through this week. It was really interesting. I am going to do the members only chat for the favorite legal TV shows this week as well. So we've got a lot of content coming and it is going to be very fun and very exciting this week. And continue to tell me what content you want. A lot of you sent me stuff last week that I'm catching up on this week. Misty, is this the indictment from last week? This is from the hearing last week. Yes. So Lois said they can have separate charges even though they're being tried together, aren't they? Or am I wrong? They are being tried together. It has to come out of the same facts and circumstances, right? So they can't try like this happened in Hawaii 3 years ago and this happened in Idaho last year. They can't try that kind of thing together. But as long as the whole thing is basically part of the whole same facts and circumstances, then yes, they can be tried together. Yes, Cherry or Sherry. Murdaugh. Murdaugh is definitely one we're also going to keep our eye on. Not that, Karen. Why is this a joint trial? It's already so complicated. Can you explain the reasons, positive, negative? Yes, and we did a full video on this if you want to check it out when they had this hearing. Basically, in the interest of justice and to save money, they're trying them together. They think that it will be potentially inconsistent verdicts if they try them separately. And just to save time and money, it would just be insane to have to do this twice, basically is what the state argued and the judge agreed. Janine, if they find both guilty of conspiracy but only one of the murder, would they both get death penalty? It's up to the jury. I think the death penalty can be a sentence for the conspiracy to commit first-degree murder in Idaho. So they could get the death penalty both, even if only one of them is convicted of murder, but it doesn't necessarily mean they will. Natalie, thank you, Peter. I sent you the link to the Camille Vasquez podcast, so I'm looking forward to your commentary on that. Thank you. Thank you for sending me the link. Thank you, Donna. Yeah, I see some people commenting about her smiling and her facial expressions. It was very strange to watch. Somebody else asking about mental health. There have been mental health issues throughout this case. It is, yeah, Rich Cat says mental health part of the defense. I don't think it's part of the defense as I've seen yet, but it could be. And she was found incompetent to stand trial for quite a while. So I wouldn't be surprised. Patricia said, could she be found incompetent again due to her demeanor? She's just looked to be having too much of a good time. Yeah, I mean, there's no telling whether or not she's going to be found incompetent to stand trial again. RL Boise, how do the courts determine how long a court case will take? So there's a couple different ways. A defendant can either demand speedy trial, which we saw, I think, in the Murdaugh cases where they did that. We can see it take as long as it takes to get all the discovery done and make sure there's a fair defense put up and the defense has enough time to do everything they want to do. There can be delays purposely by either side because they want it to take forever. And then there can be delays that are like COVID or backups in the court or something that you can't control as a court system by the judge, the lawyers, the clients. There's certain things out of our control that sometimes delay cases. Janine, did you see the Parkland shooter trial is now the defense case in chief and his attorney gave opening statements today? I didn't see their opening statements yet, but I did know that it had gone over to the defense and that they were basically taking a break until today. So we will keep up with that if you guys have interest as well. All right. I'm going to take a couple more questions here before we sign off for today. But like I said, at 4 o'clock, Vanessa Bryant trial update. Don't miss it because some interesting stuff is happening in that case. And I have a pretty strong lean as to how I think it's going to go. So I want you guys to check that one out. Will it be one of them or two or one for each? Oh, one jury. I believe it's just one jury for both of them. I believe that's how they're doing it, but I haven't seen, there are certain courtrooms that have 2 jury boxes for death penalty cases like this with co-defendants where one jury does each part of it. It's pretty crazy, but I don't think that's how it's going to be. Let's see what else we have here. Oh, Barbara said, how long does the court decide how long the trial will be? Okay, I thought you meant like the whole case. So a trial is almost always agreed to by the parties. And if they can't come to an agreement as to how long they need for trial, then the court will step in. But the court has to be very careful because everybody's got rights. And if we talk about civil cases, there's a little more leeway for the court or discretion for the court. But in criminal cases, if the defense says, no, judge, we need 26 days to put on our case, it's very hard for a judge to say no to that because it could violate the defendant's constitutional rights. Same thing with the prosecutor. The prosecutor said, judge, we need 21 days to prove our case and not a day less. It's going to be really hard for the prosecutor to say no. They can sometimes put pressure on each side to try to hurry the case or pick a quicker trial schedule. But for the most part, the two parties, meaning the state and the defense or the plaintiff and the defense, have to agree. Like every one of my trials, we agree how long it's going to take. And none of us want to waste time or none of us want to waste time or, make a trial take longer than it is. John O'Rourke, fill us in on your verdict. Congrats, our lawyer. So, John, the verdict is not completely final yet, but I'll give you a little insight as to what happened. So, we're fighting against an insurance company as per usual. We were willing to settle the case for under $100,000 early on because we knew our client was going to need more treatment. They offered us like $30,000 or something like that. And so we took the case to trial because our client got T-boned in an accident, had some injections and RFA, and he was going to need future treatment like that. And we took it to a jury because the insurance company was just totally unreasonable the entirety of the case, basically just brushed us off and said no the whole time. So our client exercised his constitutional right to have a trial by jury. We went before jury and they gave us a verdict of $936,000. Plus we are going after attorney's fees and costs now, which is going to make it, somewhere around $1.5 million is what we're hoping for the final judgment. So we were pretty excited about that. And it was in a pretty conservative jurisdiction in Pasco County. So we are pretty excited about that justice for our client. Honestly, I mean, I talked about being a big fan of justice and closing argument. You guys would be shocked at how much this YouTube community was used in a real life potential 7-figure trial. So thank you. Team effort, all of us. Rich Cat said, am I the only one who's become much more interested in following trials because of Peter? Thank you, Rich Cat. Question, do you ever have to ask for more time mid-trial? I never have because I usually like to overestimate because I don't want to tick a judge off. So if I think I'm going to need 4 days, I tell the judge 5. We had a 4-week trial one time. We told the judge it may bleed into the 5th week, and it didn't. So I've never gone long either. I'm pretty good at estimating, who we're going to call, what we're going to call, things like that. So usually not. Thank you, everybody. Yes, it was incredibly stressful. It was incredibly stressful. It was a roller coaster. Yes, Barbara. Too bad it wasn't recorded. It would have been really fun for you to watch. It was stressful, man. Trials are really stressful. I always say give grace to these trial lawyers we watch because I've been in the arena and it's not easy. There are really good lawyers on the other side and we're held to the ropes and everything was tough every day, every time, someone's getting cross-examined, when I'm up there trying to pick the jury and he's talking to the jury, when I'm doing closing arguments, when he's doing closing arguments, it was a tough battle for sure, but it was interesting. All right, let's see what else we got. It's just crossed 30 minutes, so I do have to take off here. Can you appeal injury cases? Yes, you can. Thank you guys so much for all of your congratulations. I appreciate it. Thank you, Julia. Fantastic speaker, whether it be on YouTube channel or in front of a courtroom. I take pointers from you. Thank you, Julia. Appreciate that. Very kind. So glad all the work paid off, Pooh Bear. Well, there was a lot of work. There was a lot of work. A lot. But yeah, it did. It paid off. And it's really rewarding to see your client at the end, because that's the thing that's so stressful. You look at him and you're like, we lose and get a 0. This poor guy's gone through so much. But okay, that's all I got for today. We'll talk more about that trial, get into some of the details maybe later. But I appreciate all you joining me on here. I will talk to you in about 30 minutes about the Vanessa Bryant case. So check that one out. I'll try to get in the comments if I can, but I appreciate you all. Yes, Angela, I will see you at 4 p.m. But for now, that's all we got. I'm taking off. Bye-bye.